Yes, any mention? Us.
Your Lordship, I beg to mention item number 10, Your Lordship. My Lord, I appear for state respondents.
Any objection?
No, my Lord, I do not have any objection.
How long?
Supplying for the petition, Your Lordship.
How long?
2 weeks, Your Lordship.
Made by the petitioner. This is matter to 2 weeks.
Obliged, Lordship.
Please, Your Lordship, I beg to mention item number 14, Lordship.
Yes.
I pray for some more time, Lordship.
You are for?
I'm for the petitioner, Lordship.
Yeah.
Objection, Lordship.
On pre-made by the petitioner, this is matter to 2 weeks.
Highly obliged, Lordship.
Please, Your Lordship, I beg to mention item number 9.
You are for?
For the state respondent.
I am the petitioner, my lord, in this matter. It's been pending for some time. A week's time is okay, my lord.
Respondent whom? What you are
The
For
state
state respondent.
State respondents.
on pre-made by the state respondent seeking adjournment and the same not being objected to by petitioner. This is matter after 1 week.
Objection.
Please, Lordship, with the supplementary list hearing. Lordship, may I have some personal difficulty in this matter because Lordship may kindly come to the cause title. One of the petitioners.
My Lord, the lead petitioner expired and then was substituted.
Lordship, may let me some.
Certainly, no. Only on the court after.
Lordship, kindly come to page 3, the cause title, page 3. Petitioner number 20, Lordship.
Oh. Nikayo, list this matter before any other bench other than this bench. Obliged.
Please, Your Lordship, I beg to mention item number 8.
Therefore,
I'm for the petitioner, Your Lordship.
For the state respondents 1 to 3.
this is a 2019 matter.
Lordship, today we're having some. The County Council is having some personal difficulties.
Accommodation has been sought for by the petitioner on the ground that the senior counsel is not ready.
Yes,
or he's not
Lordship.
here.
He's not ready. He's here, but he's not ready regarding this matter.
On the ground that the senior counsel is not ready to be heard in this matter. On premier, the same is allowed. List this matter up to 1 week.
Lordship, similar prayer for item number 15.
Lordship, I'm appearing on behalf of respondent number 5, Your Lordship.
On pre-meet with petition, list this matter to 2 weeks.
I do pledge.
Daily cost list item number 1.
Yes.
My lord, I appear for respondents number 4 to 9, my lord, state respondents.
But where is the petitioner?
She was here, she made a mention also, my lord, just now. The counsel assisting senior counsel. She was here. So. Yes, sir, my lord.
Yes.
Lordship, I'm praying for some more time. In this matter, I'm praying for some more time.
So it's
Why
come
is-
for admission because all the respective affidavits have been filed. We have not filed a single rejoinder to any of the affidavit.
We have already filed the affidavits. Readings have been exchanged, my lord.
My lord, even states and I believe union and all the other respondents have filed respective affidavits.
This is those land acquisition matter?
My lord, IBBF, my lord.
Okay. Why is that? Why has it come up for admission?
Yes, because it is
Any-
not yet to be admitted.
My lord.
Any?
Come up for admission hearing.
Yeah, it should come for admission hearing. Otherwise,
lord.
issue of integrity is.
My lord, yes, yes.
Okay. On pre-made by the parties, on pre-made by the land counsel for the respondents. On the submission made by the land counsel for the respondents who have submitted the pleadings in this matter. Yes, Mr. Sanghi.
My lord, I have some difficulties. 2 more part of matters are there.
So, what happened is Mr. Dengdo has submitted that the pleadings has been completed.
Completed, yes.
So we'll pose this matter for admission hearing.
Oh, well.
This matter may be posted for admission hearing. So issue of integrity is to be decided.
The other side also, they also raise. Let them
We have raised
satisfy.
also, my lord, the maintainability.
After 2 weeks, ma'am.
Place this matter for 2 weeks
Well,
for admission hearing.
I do.
Item number 2.
May it please your lordship. Your lordship, we had filed the application for removing the names of the respondents number 1 and 2 before this honorable court yesterday, my lord.
Lordship, this petition was supposed to be served on us about a week before today's date. It was served yesterday. We require some time to prepare a reply and file a reply against this, my lord. For 2 weeks, may kindly be given to us, my lord. This is that issue, my lord, will kindly recall, where they are stating that we are not a necessary party. The Lokayukta is not a necessary party. If we are not a necessary party, if they succeed in convincing this honorable court that we should be deleted from the array of parties, who is left, my lord? The private respondent. Lordship will not exercise jurisdiction against a private party. Be that as it may, Lordship may kindly give me some time to prepare a reply, a formal reply.
Ms. Anjishila Senior G has submitted that an application.
May it please your worship. Am I audible?
Yes, Mr. Kumar, I've already, your colleague has already made a submission.
Oh, sorry. I was in the other court, my lord.
If you want to detour that or to veto that, then it's up to you.
Yeah, I just want, yes, my lord. I just wanted to add what my learned colleague has placed before your lordship. Only 2 facts, my lord. Lokayukta has passed the order on a complaint filed by the complainant, my lord, and that order has been passed in a judicial capacity. Now, your lordship knows that the judicial officer cannot be, or a order which is passed in quasi-judicial capacity cannot become party to the list, cannot become party to the dispute. It is between the private complainant and the state. If the state is aggrieved, the Lokayukta, as on today, whatever legal position is there, that is being represented by the private complainant, which is before your lordship. So it's not that the legal, because if I take the proposition, my lord, that in all matters where the judicial or quasi-judicial authorities have passed the order and they are required to be impleaded and they should be arrayed as party, that will go against the whole system of the judicial process, my lord. In adversarial system, my lord, it is the private complainant which is espousing the cause of the complaint, my lord. And then your lordship, we will place the law, we will place all the materials before your lordship, whether the complaint was tenable, not tenable, what was the, and that will be defended. While Lokayukta, I put a question to myself, my lord, why Lokayukta is so much personally interested in defending its own order, it's like judge is trying to defend its own order, my lord.
Lordship, these are repetitions. These are repetitions of the petition, my lord. I'll reply to the petition, for which I seek some time.
Yes, Mr. Kumar.
And he's gone.
Now he's
Yes.
on. Yes.
So
what
I was
happened
praying
is,
that my application be allowed and local.
Anyway, what happened is you have filed your petition. The counsel for the
Yes.
Lokayukta would like to respond to this, to the same. In fact, the respondent number 3 also would like to respond. We'll give them time.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Yes, ma'am.
For
let them file reply. I'll argue them.
Deletion of the names of the respondent number 1 and 2 respectively from the array of parties has been filed for this court, to which Mr. S. Jindal, then a counsel for the respondent 1 and 2, has submitted that he may be allowed to file a response to the same. Similarly, the respondent number 3 has also made a submission that the response may be allowed to be filed as regard the said petition. On pre-made, the same is allowed. Let the response be filed within the next date fix. List this matter after
2 weeks, ma'am.
2 weeks.
Much obliged, Lordship.
Lordship, item number 6.
Even in 6, but I'm praying for some time to file an application to delete the name of the Lokayukta.
Let the matter be called up.
Yes. It was supposed to be taken up together.
Yes.
The same order.
Yes. It's not like this. We'll take it up.
Obliged, Lordship.
Item number 3.
Lordship, and in this matter, respondents have to file their affidavit.
My lord, I'm yet to receive instructions, lordship. I pray for 2 weeks' time. I'm appearing on behalf of the respondents number 1, 2, 3 and 4, lordship. The union is also here, the district council is also here, and NBCCL.
Lordship, I filed the service affidavit on respondent number 9.
Yes. Respondent number 9 has received notice.
They have received notice, but they are not appearing, so I've already filed the service affidavit.
Learned counsel for the petitioner has submitted that the notice issued upon the respondent number 9 has been affected, and affidavit of service in this regard has been filed for this court. However, none has appeared on behalf of the respondent number 9. Ms. Angela Leret, Senior J, appearing for the state respondent, for the respondent number.
Lordship.
You are for 3, 4.
3, 4, 5, and 6, my lord.
What about collector?
Collector also, lordship.
So that makes it 3, 4, 5, 6, and
3,
7.
4, 5, 6, 7, lordship.
Appearing for the respondent number 3, 4, 5, 6, and 7.
Lordship, for respondent number 8, I am having similar prayer.
What similar prayer?
Like a government council, we seek time to receive instruction whether to file affidavit or not, Your Lordship. We're just waiting for instruction from district council, Your Lordship.
Okay. To file the counter affidavit. Mr. BGK Kanta, landed senior counsel, appearing as special counsel for the respondent number 8 of the KHADC, has submitted that some time may be allowed for instructions, specific instructions to be issued as regard the filing of the counter affidavit in this case by the respondent, by the said respondent. And then who's appearing for the union?
Mr. Mozika was appearing, lordship.
None has appeared on behalf of the respondent number 1 and 2. On pre-made, this is matter after 2 weeks.
Much obliged, lordship.
Item number 4.
Much obliged, Lordship.
Lordship, I'm supposed to file the written argument. The written arguments was completed, Your Lordship. But what happened was yesterday, I had gone to Nongpo and I had got some printouts done through a pen drive. And when I came back to the chamber, today there was some show cause to be filed in the lower courts. So I put the pen drive in the laptop and the whole laptop crashed, Your Lordship. It is not that I'm making it up, but I even went to my friend who's got some expertise.
Plausible excuse.
Your Lordship, miss.
Tell me, when do you want?
27th, Your Lordship, this month. 27th.
Lordship, let it be on 26th, because one day only prior, because 27th, from 27th I will not be in Shillong. So 27, 28, 29 I will not be in Shillong. Just one day.
26th, Your Lordship.
My lord, the state has also already filed our written argument.
Yes, everybody except I have to file.
We all have filed.
On pre-made by the General Counsel for the petitioner seeking some more time to file the written argument. The same is allowed.
Lordship.
Okay, so I'll allow you to file on 28 then.
Okay, Lordship.
28?
27, 28, 29 I will not be in Shillong. I have a matter in...
Lordship, it is only for
It's
filing.
only for filing of the... You're not... Since you have filed your...
Yes, I have filed.
This
Because
is
I am, if Lordship can accommodate me on 26th, then it's just a one day. If my friend has
If you are able
not...
to do it within that time, then...
Pardon?
If he's not able to do it within that time, then what can...
Your Lordship, it is only for my part to file the written argument.
You have filed yours.
I'll give them
It'll
copy.
be on record and the matter probably would be reserved for judgment.
Oh, Lordship.
This is matter on 28th.
Highly obliged.
Item number 5.
So, my lord, well, in item number 2, I made a mention that we also want to file an application to delete the chairperson of the Lokayuk and the secretary of the Lokayuk. Because we have the same view, my lord, that they are not a necessary party. So I will file my application. If my friend has any objection, he can raise the objection at that point of time, my lord.
Lordship, that's a very interesting submission because if Lordship looks at the array of parties, page 12 of the writ petition, item number 2 of Lordship's list today, and this item, my lord, they are challenging the same order. Now, item number, in this item, my lord, the respondents are state, that is 1, 2, 3. Sorry, number 1 is the state, 2 and 3, I am 2 and 3. Number 4 is a private party. Number 5 is again state, my lord. So, by deleting me or attempting to delete my name, petitioners want a free ride, my lord, because the state is also against that order in item number 2. In this item, petitioner is also against this order. So if I am deleted, there is only private respondent left against whom there is no writ jurisdiction that can be exercised. There is state. State is anyways saying that that order is defective. So it'll be a free ride. But anyways, they want to file a petition. Let them file a petition. I'll reply. I'll reply to that.
Learned counsel for the petitioner has submitted that he may be allowed, that the petitioner may be allowed to file a petition to delete the respondent number
2 and 3.
2 and 3 from the array of parties herein. Mr. Asjinder, learned counsel for the respondent 2 and 3 has submitted that he has no objection to this prayer, but has, however, reserved his right to file a response to the same, if so filed, to the said petition, if so filed. Similarly, the respondent number 4 has also made a submission that the response to such a petition, if so filed, be allowed to be filed. On premier, this seems allowed. The petitioner is allowed to file the petition within the next date fix. This is matter to
3 weeks, my lord.
Why 2?
We need to file an application and then they have to.
Item 2 is after 2 weeks. So 2 weeks.
Put it 2 weeks.
Item 2 is there.
2 weeks. We'll fix it on the same day. Same day.
Item number 7.
May it please your lordship. So my learned friend has concluded.
Your lordship, because of on the last occasion there was a paucity of time.
Yes.
I just want to address 5 minutes, your lordship. Just some clarification. Your lordship, with regard
yes.
Lecture 4. A clarification with regard the respondents have taken a plea that the rules of 2010 has been repealed.
Repeal or amended?
Amend it because they've amend and it's like repealing the entire. It's been revised. So my argument is that, your lordship, is that whatever has been done during that period of 8 months, when that particular acting CM was done, was holding the post as acting CM of Langren at that point of time, in between December 2019 till August 2020, whatever actions he has done regarding revising the rules, whatever, that has been done without the consultation of the Darbar Hima. He has done it only amongst himself with the executive members. And when I was reinstated back in the month of August 2020, I was holding the post thereafter till date. In December 2021, we have come to learn that there was something done by the acting CM. So that is why we have informed the District Council whatever has been done, it has been done without the consent of the Darbar Hima, because that was done only among themselves. Even if it has been done, it has to be made public. It was never made in public. It was only kept among themselves, and that put an end when he was removed again when I was reinstated in August 2020. Thereafter, I held the post till date. 2021, we came to learn about it. We wrote to the executive committee saying, cannot take that into consideration. There was no reply to that. It's understood. Nothing has happened because it was never made public. It is only now again when I have been suspended that amendment has been brought to light. The revised rules. In fact, that should have been there. If it has been revised, public should have been made known. I've relied in the judgment also 1951, but if any amendment, any kind of revise of anything comes into play, it has to be made public. But in this case, unfortunately, it has come to light now only. Even a copy was not even served to me after I was reinstated back as the chief of Langri.
But that one of your communication has stated that.
Yes, I said that. I said when I was reinstated, I've submitted that when I was reinstated in August 2020, we had no knowledge about it. We came to learn in December 2021. That also a hearsay from somebody from the Ilaka. That is why we wrote to them. But if in Khasi it's specifically written Lada, if there is any kind of any revise or amendment, that should not be taken into consideration. Why? Because that has been done without the consultation of the public, of the Darbar Hima. Because that was done only amongst themselves. We came to learn that on 2021. Amendment was done in February 2019. That is also 2 years. So that's why I made a submission that it's not been made public.
So according to you, the rules of
2010
or 2006, what's the earlier rule?
There's a rule of 2010 and also amendment 2015. The book of Your Lordship, the rules of 2010, in that book it's at page 4. After page 524. These
are the rules of 2010.
Yes.
Subsequently,
there was an amendment 2015.
2015.
Your Lordship.
So, as far as this amendment is concerned, you have no grievance.
They have revised the entire.
No, the 2015.
Yes.
Thereafter, it was revised in
19
so
by the acting.
So you are aggrieved by that, the revision of 19.
I'm not aggrieved because if amendment has been done, it has to be made public. Till date, it's not been made public.
Exactly.
It has been brought to light now only in their affidavit. So, in my humble submission,
according to you, the rules of 2010 as amended in 2015 will still hold the field.
Still hold the field. Because whatever has come now, what has been done 2019, not known to the public, not published in the Gazette, that has no force of law. That is my submission.
Yes. Anything else?
And Your Lordship, I would just like to take Your Lordship to my additional affidavit. That was filed on 12 September. 6-page affidavit, Your Lordship. A thin additional affidavit. Six-page, Your Lordship. Page 7.
Yes, ma'am.
I've brought on record the suspension order. Page 7. Has your lordship got it?
Yes, ma'am.
Annexure A, page 7.
Yes.
This is the suspension order, your lordship. Your lordship, what I'm trying to submit is that the suspension order is cryptic. It's passed in a very mechanical manner, in which there were no findings, there's no observations. It's passed in a very hasty manner. And this suspension order, when they issued a notification on 18 suspending me, they came running to my house on 19 to serve me a copy. But this was not served to me, though passed on the same day on 18th. So only after I filed a writ petition, they brought this on record, in order to non-suit me and make my case infructuous. But your lordship was kind enough to allow us to bring this by way of an additional affidavit. So we brought this on record, and in my pleadings in this affidavit, I've taken several grounds as the manner in which this order has been passed. And thirdly, your lordship, no doubt there's a complaint against me by the respondent number 6. Two basic grounds they say is that of the money, the land acquisition money, and number 2, they're saying is that I have lost the confidence of the people. The entire submissions before this court on the earlier occasion was that there was non-compliance of the statutory provision provided under the rules under the Act, whereby the complaint has to be placed before the Darbar. Now, if they say that I've lost the confidence of the people, that's why I'm saying, submitting that, let the complaint be placed before the Darbar, let them face also, let us see whether I've lost the confidence of people or not. Because it's just a handful of them, because this is it's a motivated complaint. There's some motive in it behind it to suspend me. If, for interest of justice, let them face the Darbar Hima also, whether that complaint is sustainable or not before the general people. Because the basic ground is that I have lost the confidence.
But that complaint was the basis for your suspension.
Yes, I've lost the confidence. There are many grounds I've taken, but basically is the money and the confidence. So that complaint, let it go to the Darbar Hima, let them decide whether I still have the confidence or not. And thirdly, Lordship, all the disputes with regard to Constitution and Managing Committee, with regard to the money which I have received, with regard to other issues which I have taken up, all are pending before this. The issue of land acquisition is pending before your Lordship. And the issue of managing the management board, that is pending before the trial court. The issue of handing over some land for the interest for for setting up of a school under the Eklavaya, your Lordship is well about that. They have made allegation that was without consultation, and that is a suit pending before in Mokorwat also. And your Lordship, the complaint which they have filed, out of 9 to 1,000 people which they have signed in the complaint, many signatures are repeated signatures, and some signatures have been forged. So against that, a criminal complaint has already been instituted before the district court in Mokorwat against what they have done. So those also are pending before the Mokorwat court. So that is my submission, Your Lordship, that the entire proceedings, the entire procedure itself is unsustainable. Your Lordship will kindly interfere by reverting back to what the position is by placing the complaint before the Darbar Hima and let them decide. If there's any report against me, I'm not against the inquiry. They can submit a report to the Executive Committee, and Executive Committee can accordingly take steps to suspend me, to institute an inquiry. I'm ready to face that. But once the statute provides for certain things to be done, it has to be followed, Your Lordship. That's my submission. That's my submission for now, Lordship.
May please, Lord.
Who is to reply first? District Council or
District
the...
Council. I am for the District Council. My Lord, two orders have been challenged in this writ petition.
Yes.
Your Lordship will come to page 90 of the writ petition. What prompted the District Council to take action against the petitioner? Because there was this complaint that an amount of rupees 15 crores, that's a huge amount for the same ship, has been, page 90, has been misappropriated by the petitioner. So on that basis, my Lord, this order was passed by the Executive Committee. This also is under challenge.
Yes.
In the matter of alleged financial irregularities within Langren Steamship order, whereas the Seng Samla Hima Langren others had filed a complaint that there is gross financial irregularities within Langren Steamship, and whereas in order to prevent any further loss in Langren Steamship, the Executive Committee deems it necessary to take remedial steps. Now, therefore, in the interim, the CM of Langren is hereby directed that any utilization or withdrawal of funds by the CM and the Darbar Hima above the amount of 25,000 has to be obtained prior approval from the Executive Committee KHADC. Further, the CM of Langren and Darbar Hima are instructed to furnish to this office detailed statement of accounts. Now, Your Lordship will see that further the CM of Langren and Darbar Hima are instructed to furnish to this office detailed statement of account, funds and other liabilities of the Langren Steamship available as on date within 7 days of this order. Now, this was the initial order that was passed since July. But this is the complaint against you, and you are forbidden to spend more than 25,000. Now, my Lord, before I come to the other contentions of the petitioner, Your Lordship will come to page 104 of the writ petition itself. Your Lordship will come to the last paragraph of page 104.
Yes.
Because one of the allegations against the petitioner was that he had donated a sum of rupees 77 lakhs to the churches within the same ship. Now, their reply is that the third point in paragraph 3 of the complaint relates to the donation of 77 lakhs to a church where the undersigned and his family members are members. It is humbly submitted that the undersigned has made significant donation, not just to a singular church, but to all churches within Langren Steamship, that is 37 churches in total, and such donation amounted to rupees 1 crore 48 lakhs. Apart from the aforesaid 37 churches within Langren Steamship, rupees 73 lakhs was also donated to churches situated outside the Hima. Therefore, the total donation amount to rupees 2 crores 21 lakhs. As such, the allegation that donation has been given only to church where the undersigned and his family members are again unsubstantiated and highly misleading. This is only, I am drawing your Lordship's attention to only one of the points. Upon receiving 15 lakhs, instead of spending it on the public, here the petitioner has decided, and his Darbar Hima have decided to will donate it to the churches. Why give it to people? And Your Lordship, another point I would like to, Your Lordship. My Lord will come to the affidavit filed by the District Council. The affidavit filed by respondent 1, 2, 3, and 4.
Yes.
My Lord will come to page 11. This is the budget estimate for the year 2023-24 submitted by the petitioner on 1/6/2023. And my Lord will come to page 13. Page 12, my Lord. 13. These are receipts. Your Lordship will find that the total budget estimate for the year 2023-24 is rupees 22,87,000, and the actual revenue for the year 22-23 is 25 lakhs. Now, where is the 15 crores? He has not even shown that amount. That's why the District Council, this is the usual practice, whenever a complaint is received from any quarters, they ask the same to show cause. They don't take action immediately. When the executive committee is not satisfied with the complaint, then prima facie not satisfied, then they can suspend the, like in the case of the petitioner, pending inquiry. Now, my friend had cited Section 7 of the Act. You will take this book, because some of the acts, they have been amended.
In this book?
Yes. Part 2. Page 306, no? Part 2.
306.
306.
Just one.
306, Section 7. There shall be only one same to be elected from the whole of Langred Sameship, and his term of office shall be for life from the date of his appointment, provided that he may be removed from office or suspended by the executive committee if. So these are the ones. Now my Lord will come to the proviso. Now, provided that this AM shall not be removed from office or punished with suspension unless he is given an opportunity of being heard.
Yes.
Now,
that is exactly the grievance of the.
That is the grievance. But Your Lordship will come to the second proviso.
Yes.
Provided further that the above proviso shall not apply in the case where the order of removal or suspension is awarded on account of his being convicted of an offence involving moral turpitude, or in case of order of suspension pending inquiry. The suspension of the petitioner is under the second proviso, subclause 2, in case of the order of suspension pending inquiry. Now this particular section has been interpreted by the Supreme Court in the case of Charleston upheld also by a division bench of this court. I've given the last time, but we'll give you another copy. Now, this is exactly the point which was considered by the Supreme Court. Here's the case where the same Milliam was suspended.
Yes.
Now, on his suspension, we filed the writ petition before the erstwhile Guwahati High Court, taking refuge under the proviso, the first proviso, as your Lordship had pointed out, that you cannot remove me without giving a chance of hearing. And it was upheld by the division bench also. Now, the District Council had filed an appeal against the order of the division bench. Now, this is what the Supreme Court has said. The Executive Committee, constituted under the provisions of Section 6 of the UKJ Hills Appointment and Succession of Chiefs and Headmen Act. Now, Section 6 of the Act of 1959 is an exact replica of Section 7 of the 2007 Act. Initiated certain proceedings, yes, inter alia, and directed as follows. Now, therefore, the Executive Committee, after consideration of all the facts and circumstances and being fully satisfied, and
reading just a moment. There's no paragraph.
First page, madam. This is not a reported judgment. That is why.
Yes.
Now, therefore, the Executive Committee, after consideration of all the facts and circumstances and being fully satisfied, and for doing a free, fair, and impartial justice in the inquiry, hereby suspend the said Ulubores Manik's aim from the post of this aim of Milliam Ilaka with immediate effect and until further orders, in exercise of the powers conferred upon it under subclause 2 of the third proviso to Section 6 of the UKJ Hills Appointment Succession of Chiefs and Headmen Act 1959 as amended. Ulubores Manik's aim thus suspended shall cease to do any function or relating to the office of this aim of Milliam, and he shall cease to exercise with immediate effect any power, either administrative or judicial, which are attached or arose out of the office of the Milliam Sameship. Further, the Executive Committee is pleased to appoint J. Rinborn so-and-so to conduct the inquiry into the allegation made against Shri Ulubores Manik's aim and to submit the findings and report to the Executive Committee within 3 months. This order came to be challenged in a writ petition before the High Court. The learned single judge who heard this matter held that the concerned aim was placed under suspension without reasonable opportunity of being heard, and as such the requirement is statutorily mandatory quashed the said order. The matter was carried in appeals unsuccessfully, hence this appeal by special leave. Section 6 of the Act contemplates, while removing or suspending aim referred to therein, an opportunity of being heard is to be given, but the said proviso is not applicable in case of suspension pending inquiry. The order extracted earlier clearly indicates that the proceedings for detailed inquiry have been initiated and the same had been placed under suspension pending inquiry. This aspect was completely lost sight of by the High Court. However, Shri So-and-so, learned senior counsel, contended that though the order of suspension is stated to have been passed in exercise of the powers of the third proviso to Section 6(1) of the Act, which deals with suspension pending inquiry, the order has in substance been passed under the second proviso, which deals with removal or suspension by way of punishment. But on a reading of the said order as a whole, it is clear that on specific allegations, the Executive Committee wanted to hold a detailed inquiry and appointed an additional judge to conduct such inquiry, pending inquiry. He was placed under suspension. Hence, there is no basis for the arguments of Shri Raju so-and-so. He, however, contended that the nature of the matter is such that when aims are elected by elected persons, and once an inquiry has been held and the report has been given, action should have been taken quickly and cannot be prolonged in this manner. He also pointed out that the inquiry officer is yet to commence the inquiry, These aspects were not considered by the High Court while quashing the impinged order, and further, we do not know that what circumstances have caused delay in holding the inquiry. But it is clear that the Executive Committee wanted to be very cautious, this is important, and careful in taking any step, and even before placing first respondent under suspension, a preliminary inquiry was held. Material was collected, and thereafter, on specific allegations against him, they proceeded to place him under suspension pending further inquiry. If that is so, we do not think that the contention advanced on behalf of the respondents should militate against allowing this appeal. In the aforesaid circumstances, the appeal is allowed, the orders made by the High Court are set aside, and the writ petition by the respondent stands dismissed. It would be appropriate for the inquiry authority to proceed with the inquiry as expeditiously as possible. Needless to say that this order will not influence the inquiry in any manner. Since this is the exact case of the petitioner also.
So here in this case,
yes,
was a preliminary
sort of
preliminary
in the sense that we have asked for his show cause. We have asked him to file his show cause. He has filed his show cause. And on
would that constitute an inquiry?
No, no. It does not contemplate an inquiry as per se. It is only for the satisfaction of the Executive Committee. What the Executive Committee could have done on a receipt of the complaint could have placed him under suspension immediately. Here, as in the case of laborious Maniksayam, the EC said, okay, we'll ask for a show cause. In fact, that order was passed with that shown your lordship. Now, on going through the show cause, the EC found that no, these are serious allegations as against the petitioner. So we'll place him under suspension pending inquiry. And it is a suspension pending inquiry.
In the suspension order,
under the second proviso. Yes, suspension order, my lord.
Was any reference made to the second proviso of section
There's
7?
No, my lord, page 7 of my affidavit is there also, of the additional affidavit. Page 7 of the additional affidavit filed by... In our affidavit also we have filed.
Yes, yes, page 7.
No, we have not specifically said that second, but if your lordship will see the first paragraph, the last line, the Executive Committee in the interest of the Ilaka has decided to place Shri Nongtai Singh Simyang CM of Langren under suspension pending inquiry. So it is a case of, although the specific provision has not been reflected, it is a case of suspension pending inquiry.
Yes.
In fact, my lord, in 2019, when the same writ petitioner was also suspended, there was no stay order, and in fact, the writ petition remained for 7 months before this court, and inquiry was held, and ultimately it was exonerated. That is a different issue. Now, my lord, the second contention. Now, this is an important aspect. My lord, will come to the Act again. Page 3061.
Yes.
Page page 310, my lord. Section 11. These are the rules where the petitioner has placed strong reliance to contend that any complaint against the CM should first be brought to the Darbar Hima. Now, my lord, I will read section 11. The executive Darbar, it is the executive Darbar, not the Darbar Hima, shall have the power to make rules for the day-to-day administration of the same ship. In accordance with the customary practices and the provisions of this Act, including the normal collection of customary toll, which have been in practice since time immemorial, and such rules shall be submitted to the Executive Committee for approval. The rules, my lord, here it contemplates that will be made by the Executive Darbar, not by the Executive Committee, not by the Council, by the Executive Darbar, and subject to the approval of the Executive Committee. Now, para 11 of the 6th schedule,
excuse me,
I will come to para 11 of the 6th schedule Constitution. According to the petitioner, as per para 11 of the 6th schedule,
yes,
all rules
yes,
and regulations made by the council should be published in the official gazette. Now, para 11 says that all laws, rules and regulations made under this schedule by a district council, my lord, I have to press on this, made by a district council or a regional council, shall be published forthwith in the official gazette of the state and shall on such publication have the force of law. So section 11 contemplates that rules made by the district council,
yes,
not any other rules, not rules made by the EC, not rules made by the Executive Darbar. Because, my lord, section para 11 cannot be read in isolation. My lord, will come to para 3 of the same schedule.
yes,
Powers of the district council and regional council to make laws.
yes,
Now, as per subpara 1, the district council has been empowered to make laws, which includes the appointment and succession of chiefs and headmen at subpara G. Now, what is important, my lord, is subpara 3. All laws made under this paragraph shall be submitted forthwith to the governor and until assented by him shall have no effect.
yes,
So, firstly, to become a rule, a statutory rule, it has to be assented by the governor and passed by the council. Now, the executive committee, my lord, has no legislative powers. My submission. It is only an executive body. This, in fact, this point also was argued in Tikaji's case. I will come to that later, my lord. My lord will come to the page of the same book, District Council Rules 1951.
You mean to distinguish here between the
the
power of the executive committee vis-a-vis the power of the council
of the council. What I am trying to submit, my lord, is that it is only in cases where rules are framed by the council, because only the council can frame rules legally. Then the question of publication will arise.
Okay.
Just because on earlier occasions the council has published these rules in the Gazette doesn't make it sine qua non that all rules should be published in the Gazette.
Okay.
We have to differentiate between what are statutory rules and these are more or less executive instructions.
What are the parameters? What are the guidelines?
Yes. What are the
Can it be a pick and choose policy?
Because it's subject only to the approval of the executive committee. It would have been a different issue if they say that approved by the council. If it had to be approved by the council, then the question of publication in the Gazette would arise. Well, my lord, as I've said.
So according to you, what you mean to say is this, that those rules of 2019 are not necessarily to be published in the Gazette,
To be published.
because they were issued by the Executive Committee.
In fact, what led the District Council, my lord, from what I can understand, to approve those 2019 rules also. Now you see, my lord, the initial act, which my friend has annexed, very interestingly, in the initial act of the long-range steamship, Lordship will come to page 25. They have annexed page 25 of the writ petition. Relevant page 28.
Yes.
Now, my lord, the proviso after clause M.
Yeah.
The Act as it stood, in fact, provided further that any complaint against the same should first be brought to the knowledge of the Darbar Hima, and the same shall not be removed from office or punished with suspension until he is given up. So this clause was there. It was removed by the council, amended. As per the amended Act, this clause has been removed. Now, what the petitioner, rather the executive Darbar, had done, to counter that, by way of rules, they inserted this particular provision. Now, Your Lordship, basic rule of interpretation. Now, can the rules override the Act?
The rules flows from the Act.
Yes. So that what when the executive committee realized this. In fact, this is not the only point. Other points also were there.
This
So
is
the revise.
No, this is the Act, isn't it?
Yes, this is the Act.
So
Because
if you're saying that this provision was removed and brought in a rule
by way of a rule.
By way of a rule.
Yes, by way of that 2015, 2010.
So this has come in the 2019 amendment.
No, this particular provision was amended in 2010. It was removed.
When was it brought in the rules?
2015.
15.
10 also, 15 also.
So immediately it was.
5 years.
Okay, that is a separate issue altogether. But my contention here, my lord, as per the district council is.
But we're talking about the import of the.
Yes, what is the
rule
import?
as such.
Now, if such a thing is allowed, then my lord, the Act will become redundant. We'll follow the rules made by the executive Darbar.
Yes, of course.
And executive committees, these are political bodies.
So you see, so that situation has not, that anomaly rather has not been rectified.
Now they're in the process. That's why 2019 revised rules was accepted also, because in the revised rules, because even the Act says that day-to-day administration, confined to day-to-day administration and in consonance with the Act. This is a very important issue, Mawala.
Should be,
because the council has passed the Act. Now, the question is, can the executive Darbar and the executive committee overrule such a thing by way of those rules? So, Lord, functions of the executive committee, my Lord, I'll page 17 of the book of the main part 1. We are in the process of rectifying all these anomalies, my lord. In fact, this case has brought awareness to the now functions of the executive committee.
Yes.
The executive committee shall dispose of all matters falling within its purview, except certain matters hereinafter specified, which shall be referred to the district council for final approval.
Yes.
What are these accepted matters, Malad? The matters accepted are cases involving any important change in the administrative system of the autonomous district or any important departure from accepted policy of practice. B. Proposal for making regulations, rules or laws as authorized under the provisions of the 6th schedule to the Constitution of India. Cases which seriously affect or likely to affect the peace or good governance. Cases affecting the relation between government with autonomous district. All correspondence of importance with the government and all important appointments. Now 30. Savings. If any time except when the district council is in session, an emergency arises which renders it necessary, the executive committee to take immediate action in respect of any matters specified in clause A, B, C, D and E and F of sub-rule 2 of that rule. The executive committee of the district council other than the Mikir Hills or North Kachar Hills may take such action thereon as the emergency appears to it to acquire, but every such case shall be laid before the district council at its next session. So even in respect of making rules and regulations, 29 contemplates that in case of emergency, the executive committee can do it, but it has to be placed before the council later on, which has not been done in any of these cases in the rules of 2010, 15, in fact 19. So if we go to the root of the matter, in fact, these rules, there's been some, the proper procedure has not been followed.
That ambiguity still remains.
Yes, yes. Because it is only the council which has the power. This aspect of the matter.
Then how do you see? Then how do you resort to such rules then?
Yes. So in the absence of the rules, the act will prevail. But the submission of the district council is that 2019 rules are in place. It has been approved by the executive committee. My friend may say that, but you have not placed it before the council. But neither the rules of 2010 or the amended rules of 2015 also were placed before the council. And so the question of publication under 11 does not arise. That is not a sine qua non. And my lord, in respect of legislation, page 31, my lord, of the same rule 72, this is the legislative competence of the council.
Yes.
All rules which may be made by a district council under sub-para 7 or para 2 of the 6th schedule with regards to matters specified in sub-para 6 of that paragraph, and also all rules with regard to other matters which are under the rule-making power of the district council shall be drafted by the executive committee and shall be placed by the executive member in charge before the district council for consideration and information. And the district council in session shall have the power to amend, reconsider or replace them either in the council or with the help of a scheduled committee appointed by the council. And then 3 says that all rules which may be made by the district council with the approval of the governor shall be drafted by the executive committee and after being passed by the district council with or without amendments shall be presented to the governor for approval. Now publication of rules also are there. So if my friend says that these rules are statutory rules, as per the 6th schedule, that means they have to be placed before the council before they can be enacted upon. This particular provision also was cited in Tikaji, the famous Tikaji case. Paragraph 12, my lord.
Yes.
The next question that arises is whether the executive committee could take the action which it did in this case. Ordinarily, the appointment being made by the district council, the removal could only be by it. The contention on behalf of the respondent is that even if the district council had the power to remove, in accordance with the terms and conditions of the respondent's appointment, that power could only be exercised by the district council and not by the executive committee. In this connection, rules 28, 29 and 30 of the Assam Autonomous District Constitution of District Council Rules 1951 are relevant. Rule 28 vests the executive functions of the district council in the executive committee. Rule 29(1) gives power to the executive committee to dispose of all matters falling within its purview, subject to certain exceptions mentioned in Rule 29(2). One of these exceptions is with respect to all important appointments. Assuming that the office of the CM is an important appointment, the executive committee could not normally deal with it in view of the exceptions in Rule 29(2). But Rule 30A lays down that where immediate action in respect of any of the accepted matters is necessary, the executive committee of a district council, other than that of Mikir Hills or the North Kachar Hills, may take such action thereon, as the emergency appears to it to require. But every such case shall have to be placed before the district council at its next session. The order of July 7, 1959 shows that the executive committee took action under Rule 30A, as it considered the matter to be one of emergency. It is not for the courts to go into the question whether there was an emergency or not with respect to the accepted matters, and in the circumstances, the action taken by the executive committee cannot be challenged on the ground that it is beyond its power. So, my lord, on the part of the district council, I won't say that because rightly or wrongly, these rules have been approved, have been published, have been revised from time to time. I wouldn't say that they don't have any statutory force per se, but they are more or less of executive instructions, my lord. Well, my friend, when he cited the decision that all rules should be published also, now the General Powers Act also says that.
Yes.
All acts made by Parliament, by the state, have to be published in the Gazette.
So what we are looking is at a scenario where whether, you see, if they are not published in the Gazette, do they have the force of law? And if, they are not required to be published in the Gazette and still have that force, then that's also another
another
set of
another separate set of questions.
So the contention of
because these are the two main contentions. As per the proviso to Section 7, he has a right to be heard. My lord, I've satisfied your lordship with the Supreme Court judgment. And the second issue is this, that the rules of 2019 have not been published in the official Gazette in terms of paragraph 6 or in terms of paragraph 11 of the 6th schedule. These are the only 2 points. But apart from that, what I want to impress, my lord, is that the allegations as against the petitioner, per se, they're very serious.
Those are matter of inquiries. Anything else?
That is all, my lord, for now. If in case my lord has any questions, I can address the court. Because I think these are the main 2 points.
Yes. As far as the other parties are concerned,
Because we are really, we're praying a relief against the district council only, Your Lordship.
Exactly.
Their actions.
Perhaps they can assist the court more on the.
Let me keep it sometime basis. The important issue is in place. Now the status of the road is in question. And the scope of the suspension, to what extent judicial review lies. Let me see. At the back of the case, I don't need to take. But I will.
yes. Your correspondent?
Correspondent number 5. I've perused the averment of the writ petitioners. They have taken 4 grounds. Number 1 is, my lord, violation of Section 7. Right to be heard was not given to him. That is number 1. Number 2, complaint was not brought before the executor bar. So this violation is there. Number 3, para 17, it says that taking charge by me. There is a violation of the rule 9. And another last, section 9. And the last one is, there is no recommendation to appoint me as acting chief. Now,
because that recommendation has come from the Darbar Hima.
From the Darbar. And he also said that though there is no averment, but orally he advanced last occasion that I don't fall within that CMship clans,
Yes.
the ruling clans, to become
So in effect, you are out of the contention in the first place.
Yes, that is it. That is his contention. Now I'll satisfy. Now I've made the compilation, the entire acts and rules. Motion kindly. I'll give the copy to my friend. Now this is the first.
Mr. Sangeso is the only person who comes prepared with compilation and otherwise this court has to hear bits and pieces. And now I have to complete the jigsaw puzzle.
Complete compilation.
It's the same only.
Easy for lordship.
That's what it is the same. So you should be thankful to. Yes, please continue.
My lord, this 2007. Now this is the first parent act. Now, may I take lordship to Section 7.
Yes.
In Section 7, 3 provisos are there. Now, Section 7, lordship will allow me to read. There should be only one CM to be elected from the whole of Langren CMship, and the terms of office shall be for life from the date of his appointment, provided. Lordship got it, page number 3, page number 3, at the bottom, Section 7.
Yes.
No.
Term of office.
Term of office. From the date of his appointment, provided, this is the first proviso, he may be removed from the office or suspended by the executive committee, if the 10 grounds are mentioned there. Now the first proviso is there. Now the second proviso, the next page, you should kindly see, after the 13 grounds are mentioned, then provided, this is the second proviso, lordship, keep in mind, provided further that any complaint against the CM shall first be brought to the knowledge of the Darbar Hima, and the CM shall not be removed from the office or punished with suspension unless he is given an opportunity of being heard. Now these two, second proviso, it contains 2. Complaint should be brought before the executive Darbar. Number 2, he cannot be removed or suspended with punishment without hearing him.
Is this the second proviso or the first proviso?
Second proviso. First proviso in the second section 7 itself, the first part.
Yes.
So this first proviso, second proviso. The second proviso contains two parts. One is complaint should be brought before the executive part. Second, you cannot be removed. I cannot be removed without hearing. If that suspension is with punishment. Now the language Lordship kindly see, or from office or suspension with punish with suspension. Now suspension pending inquiry is not a punishment. Now here it talks about the punish with suspension. Now if the executive committee decided that he is suspended, no more further inquiry pending required, that amounts to punishment. In that case, right to be heard should be given. That is the content of the second proviso, second part. Now, third proviso it says, provided also that the requirement of the second proviso above shall not, Lordship kindly see,
Yes.
shall not apply. Now, may come straight to 2, in the case of order of suspension pending inquiry. Now, he said that our third proviso is very clear, that the second proviso will not come into play, will not operate, if the suspension is pending for inquiry.
So in effect, it means that it's not required. He's not required to be heard.
Exactly. Even district council was kind enough to issue show cause notice, collected his reply also, accumulated some evidence to satisfy the district executive committee. Without that also, district council itself has enough power to place it under suspension pending inquiry by relying on this third proviso. That is the law. Now this is the first bank. Now this was amended. But you kindly see, come to page number 10. Page number 10. This is the first amendment of the Parent Act 2007 was amended 2008. This was published on 2nd September 2008.
Of the Act.
Yes.
Amendment of the Act.
Yes, amendment of the Parent Act. Till 2008, the so-called rule was not yet born.
Yes.
Now I will take this content later. Then I'm throwing the Lordship the journey of the Act here and the rules. Now Lordship will come to page 15. The first rule was framed. Page number 15.
Yes. Yes.
Now, my lord, the section 3 of page 15 itself.
3. Rule 3.
Now, yes. Amendment to section 7 of the Principal Act.
Yes, section 3.
Yes, my lord. The entire proviso to section 7 shall be deleted and substituted by the following. Now, the second proviso was completely deleted and substituted following. Now, provided that the CM shall not be removed from office or punished with suspension unless he is given an opportunity of being heard. So, second part of the second proviso in the first Parent Act retained, but the complaint we brought before the executive power was removed by this amendment. And provided further, it says, repeat the same. The above proviso shall not apply. Shall not apply again. Number 2, in the case of order of suspension pending inquiry. So the law was flowing without any disturbance. That termination or suspension with punishment, if you want to invoke this one, you give him opportunity. But if your suspension is subject to pending inquiry, this second proviso is not going to apply. Therefore, as I said, in the Parent Act, even the Second Amendment Act 2010, show cause is not required to issue. And that is the principle applied in all the service jurisprudence also. I'll cite some Supreme Court decision also. So the leave of contention advanced by my friend that he entitled for hearing, it is not tenable, not tenable. Now I'll take to the rules. Now this rule, Lordship, we kindly turn to page number 20. Page number 20, Rule 3.2. Nomination election for the office of CM.
Yes.
This is what we call nomination election for the office of CM. This is the heading of the rule. Now, page number 23. This rule contains sub-rule 10, prohibition.
Which?
Page number 23.
23.
It ended up with sub-rule 10, prohibition.
Prohibition.
Yes. Now that was the 2010 rules.
Yes.
Now subsequently the 2015 rules. Now Lordship may kindly come to page number 32 of 2010 rules. Page 32. At the bottom may read, certified that administration of long-range Sameship Rules 2010 passed by the same and Darbar of the long-range Sameship on the 11th December has been approved by the Executive Committee. Now the act was passed, the rule was framed by the Executive Darbar, long-range Sameship, and approved by Executive Committee.
These are the 2010 rules.
2010 rules.
Yes.
So 2010 rules is completely silent about the bringing of complaint before the Executive Darbar. Requirement is not there. Requirement is not there. Because the parent act has removed that one. That it doesn't serve any purpose. Now, Lordship can see the position hierarchy. Executive Committee is above the appointing authority, suspension termination authority. Now, if the complaint is brought before the Executive Darbar of the same chief, and the chief is the head of that same chief, nobody would have, either acting chief, deputy chief, would have the courage to consider his case. Perhaps District Council realized this wisdom. Therefore, they deleted by the first amendment. Now, District Council, the Executive Committee Darbar, Executive Darbar, Long-Range Sameship brought this 2015, page number 33. 33. And may I come that relevant para? Now may I come to page number 38, where my friend is relying. It says, amendment to Rule 3, Subrule 2 of the Rules 2010. The existing Rule 3.2, a new Subrule 2, 3.2.11 be inserted with the following, namely, the Executive Committee, in due consultation with the HIMA, determine and notify the number of polling stations of the election of the CM for the convenience of the electors, voters. In the existing Rules 3.2, a new proviso shall be inserted with the following. Now, my friend is relying on this. Provided that any complaint against the CM or acting CM or before any action is taken shall first be brought before the Darbar HIMA for necessary discussion and decision, and such Darbar shall be convened and presided over by the Deputy CM or any other member elected by the members present in the meeting in case of his absence. Now, my friend is relying on this. This is directly goes against the Principal Act. Principal Act incorporated this earlier, they have deleted. District Council, by exercising a law-making power. Now, District Council, the Long-Range Executive Darbar has brought this. and district council.
This is the rule of the executive dabar or the executive committee?
Yes, executive dabar approved by the district council.
Again,
as a
approved
committee.
by district council.
Yeah, approved by district council. Yes, that will come. But framing of the rule was given to the district council, the executive dabar. Approval was given to power was given to the executive committee. Therefore, the rule framed by executive dabar HIMA, nor approved by the executive committee, amounts to framing of rules under the sixth schedule. That is, senior has a special counsel has pointed out clearly. Rule making power is only vested with the district council.
That is para
yes.
11.
Para 11, read with section rule 2930 as well as 72. I'll come 72, that portion also. Now, this is the rule framed by the Darbar of HIMA, approved by the district council. So, acquiring the approval from executive committee doesn't change the status of the rules. Nomenclature doesn't matter. Now, this is my friend is relying on this. Assuming that this is applicable, this cannot go against the Act. It runs contrary to the Act. Therefore, the Act will always prevail. I'll cite that judgment also. Now, this is the position. The last amendment. Now, my friend said this was approved and published. Gazetted. I'll come that this publication is not required. Now, last 2019 amendment, page number 58. And my friend here say that this is, since it is not published, page number, my lord, may I take it 57. Now, 57 is the approval of the revised rules. May I read, man? Approval of the administration of long-range samemanship revised rules 2019. With reference to the subject cited,
yes.
I'm to inform you that the Executive Committee, KGTC, has an empower under Rule 11 of the Act 2007, approved the Administration of Long-Range Samemanship Revised Rule 2009, which was passed by the Executive Darbar Long-Range as conveyed and such. Now, this was approved by the Executive Committee. So far as my lord, approval under Section 11 requirement, it is done by the Executive Committee. Now, this revised rule, Lordship, can you say Section Rule 32, page number 59.
Yes.
59. Well, nomination and election. Now it continues. Now the proviso they have inserted in the first amendment 2015 was deleted. Lordship, kindly come to page number 62.
62.
62.
60.
62. 62. 62.
Yes.
62. So it ended up with the sub-rule 10.
Yes.
So proviso was stands deleted, and this was approved by this Council Committee.
This is prohibition.
Yes. Prohibition, below the prohibition they have inserted in 2015 rules. They have inserted that proviso.
Yes.
And the 2019 they have deleted that proviso. Lordship, can you see the differences? Page number. Lordship, can you come to page number 38?
So this speaks only about canvassing.
Yes. Now, Lordship, can you turn back to 38 again? The amended one. 2015.
38.
38. Page 38.
Yes.
38. And there they have said in the existing sub-rule 2, 3.2, a new proviso shall be inserted with the following.
Yes.
This proviso was inserted below that prohibition. Sub-rule 10. This was now, this proviso was then deleted by 2019. That is page number 62. So requirement of placing a complaint before the executive is no longer. as per 2019 rules. Worship got it.
So in 2019,
Earlier, my lord.
in 2019,
19.
this proviso is no longer there.
Yes. Now in 2019, sub-rule 11 of clause 11 of sub-rule 2 of rule 3, as well as the proviso inserted in 2015 rules.
Clause 11?
Yes.
Clause 11.
Lordship, can you see page number 38?
Yes, 38.
38, it says, in the existing sub-rule rule 3.2,
Yes.
a new sub-rule 3.2.11. So if we read from the ending side, other side, it will be clause, it should be clause 11 sub-rule 2 of rule 3.
Yes.
So what they have inserted is clause 11 was inserted along with the proviso. The proviso.
Yes.
Now this is 2011. In 2019, this clause 11 along with the proviso was stands deleted, amended.
Or this clause 11
Yes.
also would
Also
not
removed.
include the proviso.
Yes, including the proviso.
No, the proviso is separate.
Yes.
Proviso speaks of the rule 3.2 in totality.
Yes, yes.
But the proviso would not relate only to clause 11.
It is a different subject.
Different.
Yes,
Sorry.
different subject. But clause 11 also removed by the 2019 amendment.
That has got nothing to do.
Yeah, yes. Now only the proviso.
But you are referring to this clause 10. See, this speaks only about canvassing.
Yes, prohibition of canvassing.
Yes.
Yes.
So what has that got
Now
to do
below,
with the proviso?
yes. So 2019 rules, revised rule ended here.
Intent.
Ended here. So that means
So
the
the
proviso was then deleted, omitted. So on the day of suspension of my friend, this proviso was not in the rule book. Therefore, reliance made by my friend is not correct. Not correct. Now, when I come to, before I go to the decision, now, with regard to other point, my friend said that I am not included in the ruling family.
The clan.
The clan.
Eligible clan.
Yes. But may I take a lordship to page number 2 of the same compilation? Definition, my lord. Definition in the next, the page number 2. Same clan, my lord. But who are the same clan, my lord?
N.
Yes, N. Same clan means the Simeon clan of Langrin Sameship, who are the descendants from the womb of Karuyan Simeon, Simeon and Laban Simeon. The genealogical table of the Siem's family of the Langrin Sameship is as shown in the appendix 1 of this act. The Sameship clan of Langrin Sameship has been become extinct since the such. Now the 3 worms they have mentioned here, 3 worms. And genealogical tree is mentioned in the appendix 1. Now, appendix 1, where we come. Now, in the appendix 1, page number 9. The worm of the respondent number 5
Yes.
is not there, admittedly.
Not there.
My clan is, my worm is not there. Now, subsequently 2008 amendment, page number 10, the first amendment of the Principal Act.
Yes.
It was amended. And Lordship, kindly see page number 11. Page number 11. N amendment. It says, same clan means Simeon clan and the Simli clan of Langrin Sameship, with a native residents of the same ship. The genealogical table of the same ship clan and the Simeon clan of Langrin Sameship is shown in appendix 2 and 3 respectively, and such. Now, earlier they mentioned only Simeon clan. Here, Simile clan also there. Now may I come to the genealogical tree. Page number 30.
Yes.
Page number 13. Lordship, kindly see page number 10, appendix 2. Now, when we read the clan of the respondent 5
Yes.
is a serial number 4. Purport. Lordship, can you see? Lordship,
Four.
yes, number 4.
Where name?
4. Purport. Lordship, can I just assist? For pun or no? For pun or
Which side?
Lordship, may I indicate over that table?
Larpon.
Yes.
Larpon or
yes.
Larpon.
Purport.
Or you have 1, 2.
Yes. Two what?
This ka for fun?
Yes.
Okay, for fun.
Yes. Yes. We come from them.
You come from this?
Yes, from this one. So admittedly, my lord, we come from the womb of the ruling clan. Ruling clan.
Yes.
Ruling clan. Ruling clan. Even my friend is not pleaded in his petition also, but since orally he advanced, I clarify this one. And the other point, my lord, he says that recommendation. Recommendation, Lordship, kindly come to page number 5 of that compilation. Subsequent amendment was retained the same provision.
Yes.
Now, section 9, subsection 1 and 2 may I read. If at any time the office of a CM becomes vacant as a result of death, resignation, retirement, due to old age, removal, or suspension, the Executive Committee may by order in writing appoint any other male belonging to the Simeon clan of Langren Simship duly recommended by the CM clan through the CM to function as an acting CM who shall exercise all the powers and functions of the CM. Now, 2 is important. No acting CM shall be appointed in without the recommendation of the CM clan through the CM saying. Now, recommendation.
Yes.
Now, the statute do not provide that recommendation would be after the death of the CMship, after retirement, after suspension, or after termination. What is the essential requirement under the Act is that recommendation should be there. And recommendation should come from that CMship family. Admittedly, my recommendation is there on 8 August. Coming to know that my lord, serious complaint has been lodged against him, hoping that in the event of eventuality of suspending him, the interest of the ruling clan is to ensure that somebody should come as acting chief, so that the chair will not be vacant, clanship will not suffer, public will not suffer. So the recommendation was there. District Council has the liberty to ignore it or accept it. District Council accepted that recommendation after suspension and placed me as acting chief. So the statutory requirement is whether I'm recommended by the ruling clan, recommended. Recommendation is there or not, recommendation is there. Whether it is prior or after, my lord, that depends on the circumstances of the case. Circumstances of the case. So legal requirement is fulfilled. Now,
yeah, but how can you take your prior, as in this case?
Yes.
It appears that you have foreseen the contingency or the events that is.
Exactly. The nature of the complaint, my friend may explain. The entire CMship lost the confidence. Many. After coming to know that the huge compensation was misappropriated, withdraw from the collector during the pendency of the suits, diverted half of the amount given to his own mother, and remaining amount given to others, so they lost the confidence. Therefore, the ruling clan was apprehensive that if the district council take a coercive decision, it requires we need to keep somebody as an acting chief. So that was a recommendation. There is no statutory power. But I should not give recommendation. If there is no suspension, my recommendation will not give any effect. You'll die there. But in the event of suspension, termination, there is nothing wrong to look into the recommendation given by the ruling grant prior or after. So that is my recommendation was correct. Now the another part may I read straight away from here. Rule 9.4. My friends are taking over the office.
Yes.
It says, where there is a change of incumbent on account of subsection 1 above, there should be a proper taking and handing over the charge of the office properties, office properties, duly recorded in writing between the predecessor and the successor incumbents in the presence of the reliable witnesses. Any deliberate or willful violation of this provision shall be treated in an act of criminal breach of trust, and the incumbent is liable to be proceeded with accordingly. Further, such person shall henceforth not eligible to hold any post or office under this. Now, the handing over what? It is not the assumption of the office. My Lord, imagine, my Lord, if the contention of the petition is accepted, then until unless he hand over an entire thing, office will not be functional. Now, if a situation arises where the incumbent walk away with the properties, office records of the entire same ship, walk away 2-3 months, that doesn't mean that, my Lord, office of the same ship cease to exist. It is not. Therefore, the suspension was with immediate effect. If the suspension is not with immediate effect after 15-20 days, then I cannot take over. But suspension of my friend was with immediate effect, and I was given the charge. So it is my duty to take over assume the office. So I assumed the office on date 19 September itself. Please, even the suspension, I was appointed on 18, both of us. I assumed the charge on 19, the office. And later on, my Lord, I requested him to hand over the records to fulfill these requirements. So the claim of my friend that he is still in office because there is no proper way of handing over office records, the seal. That is not the object of the act. Now, may I come to that, the framing of my entire cases, my Lord, as a senior has pointed out, the rules framed by executive part, approved by executive committee, it is not the rules. It is not a rule. Now, may I just take that act. How to frame the, my Lord? Frame the rules by district council. Lordship may take the Lordship attention to Assam and Meghalaya autonomous districts, constituent district councils rules 1951. Yes, it is contained in part 1. Okay. Other rules, Learned Senior Special Counsel has emphasized well. I will not repeat that one. May I come straight to Rule 72.
Just a moment.
72. Chapter 6. Page number, this it might be page number 25. Chapter 6, Lordship may kindly come. Rule 72.
Chapter 6. Chapter 6.
Rule 72.
Just a minute. Constitution and Council rules.
51.
This is under part. Part 4.
This is chapter 6. And the heading is legislation. Rule 72.
Part 3. Legislation.
Yes, legislation. The heading legislation.
This is chapter.
Because the District Council Act, my lord, framing up a rule, unlike the union and the state government, it falls under the legislative power.
Okay.
Normally, in the case of state government and union of India, framing up rule is a delegation of legislative power. It used to give to the executives, the government, and the government used to frame it, and governor, in the name of governor, they used to issue it. Now here, the power of legislation was not given to the executive committee, unlike the state and the union of India.
Okay.
It is retained by the district council itself, the power of framing rules.
Yes.
So, Lordship, again, if Lordship allow me to read, all the rules which may be made by the district council under subparagraph 7 of paragraph 2 of the 6th schedule with regard to matters specified in subparagraph 6 of that paragraph. My lord, we may not consider that. And also, this is important, also all rules, this will be, all rules will follow, my lord, fall under para 11. Now, all rules, also all rules with regard to other matters which are under the rule-making power of the district council, rule-making of the district council, not the executive committee.
Yes.
The law is very clear. Shall be drafted by the executive committee. Now, the drafting committee is given to the executive committee. They are not on drafting committee of the KHATC and shall be placed before the CEM, before the district council for consideration and confirmation, and the district council in session shall have the power to amend, reconsider, or replace them, either in the council or with the help of a select committee appointed by the council. Now, the rule can be drafted by the executive committee, placed by the CM, CM placed before the council in session. Council in session has the power to amend it, remove it, confirm it. If they don't want, by the select committee is the elected person. The rule is very clear. So the power of the framing rule is with the committee, the district council. Now may I come to sub-rule 2. All rules thus made and confirmed by the district council shall be authenticated and signed by the chairman of the council. A copy of such rules shall be submitted to the governor for information through the secretary, tribal affairs, and a copy of thereof shall be sent to the chief executive member. Now, after clearance from the district council, it is sent to the governor for his information. Now, 3. All rules which may be made by the district council with the approval of the governor shall be drafted by the executive committee, and after being passed by the district council, with or without amendment, shall be presented to the governor for his approval. Now, for approval 1, they have to place before the governor. Now, 4 is important. Now, all rules are made, all rules thus made and passed by the district council after being approved by the governor, in case of rules requiring such approval. You see, approval under any provision in the 6th schedule shall be published in the Gazette of the state, and such publication shall come into force. Now that means that the rules which do not require for approval of the governor, it doesn't require publication also. But if the rules that require approval of the governor, then it has to be approved by the governor and published in the state gazette. Now the rules relied by my friend 2015, 10, 15, 2019, admittedly framed by the executive power, approved by the executive committee. This is not the rule. Not the rule. With the meaning of the rules mentioned in the Act. It is very clear. Therefore, at best, if the 2010, 15, 2019 rule is in existence, their status is not more than the status of executive instructions framed by the executive committee. Now, may I just place a decision? Therefore, my first line of argument is that, along with, I support the view of the learned special senior counsel, that the rules of all these three rules are not the statutory rules. It is only an executive instructions. And therefore, when it runs contrary to the Act, even assuming that the rule is a statutory rules, but if it runs against the Act, the principal Act, what the Supreme Court says.
The Act will take precedence.
Yes. Act will. Therefore, the citation document, I just cite this judgment, 2016 judgment. It's very clear. May I take the first flag? First flag may come to my lord, page number para 36. and 41, relevant para. May I read with lordship permission?
This is not reported.
It is it must be reported, but it is properly downloaded from the Supreme Court website.
But you see, more often than not, it would be better if you
yes.
get a reported citation.
Right. So, lordship, for the time being, look at this para 63, 36, the first flag mark.
Yes.
Yes. May I read, madam? There is one more and most important reason for which the 1997 rules cannot be said to be legal. 1981 Act deals with the salaries and perquisites to be given to all the ministers, including the chief ministers. The said provisions are statutory, but the 1997 rules are not statutory and they are only in the nature of executive instructions. If there is any variance in statutory provision and executive instruction, the statutory provision would always prevail. This is a very well-known principle and no further discussion is required on the subject. When 1981 Act enables the Chief Minister to have residential accommodation only during the tenure and up for 15 days after completion of his tenure, 1997 rules providing for accommodation for life to the Chief Minister cannot be said to be legal and valid. For this sole reason, validity of absence cannot be upheld. Lordship, may kindly come to 41, para 41, the second flag mark. Short paragraph. There could not be any dispute that when the rules and a regulation or executive instructions are contrary to any statutory provision, the statutory provision would prevail and the rules or executive instructions, so far as they are contrary to the statutory provision, would fail. It's very clear, very clear. So even assuming that either the rules of 10, 15, 19, for example, is inexistent and considered as a rule or executive instructions, it goes against the Act. So it will not, Act will prevail. And even if, my lord, contention is, even if these rules are there, along with the proviso, for the time, forget about 2019 rules. 2015 rule is there. Still then, it cannot prevail over the Act, the principal Act. Now the next point is, my lord, the purpose of the suspension. My lord, before I come to the purpose suspension, may I just take your lordship attention to 2009 volume 5 ACC, page number 151. 2009 volume 5 ACC, page number 515. Para, my lord, 22 to 23.
Yes.
It says, as noticed herein above, the recruitment and promotion policy rules were framed in exercise of the powers conferred under the regulation referred to herein above. But be noted, there is no power vested in the corporation to make any rules, since Section 44 of the Act confers power to make rules only in the central government and not in the corporation. The corporation is entitled to make any regulation which it did and published by way of notification referred to in herein above dated sunset. The recruitment and promotion rules are not even notified in the Gazette, as it is not required, whereas the service regulation referred to above would have been gazetted. The Indian Airlines Corporation Employee Service Regulation 1955, which are made in exercise of the powers conferred by upon the corporation by the Act are undoubtedly statutory in nature, but the recruitment and promotion rules are not statutory in their nature. These rules are not framed in exercise of any rule-making power. Mere administrative rules are not legislation of any kind. They are in the nature of statements of policy and the practice of government departments, statutory authorities, whether published or otherwise. Statutory rules which are made under the provision of any enactment and regulation subject to parliamentary approval stand on a different footing. The administrative rules are always considered and have repeatedly been held to be rules of administrative practice merely, not rules of law and not delegated legislation, and they are no statutory force. Mere description of such rules of administrative practice as rules does not make them to be statutory rules. Such administrative rules can be modified, amended, or consolidated by the authorities without following any particular procedure. There are no legal restriction to do so, so long as they do not offend the provision of the Constitution or statutes or statutory rules, as the case may be. Not here, admittedly, corporation frame the proportion rules without any power. So nomenclature of the rules may be rule, but it doesn't acquire the power of the statutory rules. Same thing, my lord, the rule framed by the Parhima and approved by Executive Committee is not a rule under the 6th schedule. Now another, my lord, may just come to the basic object of suspension, my lord, is to, my lord, 3 purposes, or I recollect, my lord, my humble submission. Number 1 purpose is to restrain the delinquent officer not to perpetuate his misconduct during the pendency of the inquiry. That is purpose number 1. Number 2, my lord, to enable the complainant authority to unearth the truth of the allegation complaint without any influence. And number 3 is the allowing the complainant and the delinquent person to participate in the inquiry process fairly. Therefore, the Apex Court held that suspension pending inquiry judicial review is very, very limited. Number 1, my lord, malafide ground, violation of these rules. As I pointed out, my lord, there is no violation of rules. May I take your lordship attention to, my lord?
Because suspension per se cannot be interfered by the court.
Yes.
It's only the procedure that
the procedure
and
aspect.
The process that is in question.
My lord. Yeah, admittedly here, malafide question is not arised. It is not pleaded also. Only his sole ground is the violation of the rules. Against the rules. That is the only issue. Now the purpose, my lord, 1994, volume 4 ACC. 1994, volume 4 ACC. Page 126. Relevant para 13 and 14.
Yes.
My lord, with lordship permission, I read this one. Para 13 may I start?
Yes.
It is thus said the law that normally when an appointing authority or the disciplinary authority seeks to suspend an employee pending inquiry or contemplating inquiry or pending investigation into grave charges of misconduct or defalcation of funds or serious acts of omission and commission, the order of suspension would be passed after taking into consideration the gravity of the misconduct sought to be inquired into or investigated and the nature of the evidence placed before the appointing authority, and on application of the mind by disciplinary authority. Appointing authority or disciplinary authority should consider the above aspect and decide whether it is expedient to keep an employee under suspension pending opposite action. It would not be as an administrative routine or an automatic order to suspend an employee. It should be on consideration of the gravity of the alleged misconduct or the nature of the allegation imputed to the delinquent employee. The courts or tribunal must consider each case on its own facts, and no general law could be laid down in that behalf. Suspension is not a punishment, but it is only an act of forbidding or disabling an employee to discharge the duties of office or post held by him. In other words, it is to refrain him to avail further opportunity to perpetrate the alleged misconduct, or to remove the impression among the members of the service that the religion of duty would pay fruits and the offending employee would get away even pending inquiry without any impediment, or to prevent an opportunity to the delinquent officer to scuttle the inquiry or investigation, or to over the witness or the delinquent having had the opportunity in office to impede the progress of the investigation or inquiry, etc. But as stated earlier, each case must be considered depending on the nature of the allegation, gravity of the situation, and the intelligible impact it creates on the service for the continuance of the delinquent employee in service pending inquiry or contemplated inquiry or investigation. It would be another thing if the action is actuated by malafide, arbitrary, or for ulterior purpose. The suspension may be stepped in aid to the ultimate result of the investigation inquiry. The authority also should keep in mind public interest of the impact of the delinquent's continuance in office while facing departmental inquiry or trial of a criminal charge. On the facts in this case, we are of the considered view that since serious allegation of misconduct had been alleged against the respondent, tribunal was quite unjustified in interfering with the order of suspension of the respondent pending inquiry. The tribunal appears to have proceeded in haste in passing the impugned orders even before the aim is tried on the orders passed by the appointing authority. The contention of the respondent, therefore, that the discretion exercised by the tribunal should not be interfered with, and this court should be allowed to interfere with the exercise of such discretionary power cannot be given acceptance. So the law is very, very clear, my lord. The impact of them allowing carrying this nature of allegation, and if he is allowed to sit as a chief, how the inquiry will be proceeded. So the district council has applied a judicious mind, placing him under suspension. He has enough opportunity to place his case. So also the complainant also. Therefore, the suspension order passed by district council is absolutely within the permits of law. And my appointment, my lord, though he challenged as I submitted, my lord, is well within the parameters of law under the Act. So it doesn't call for interference. My humble submission.
May it please your lordship. Your lordship, the respondent number 6 had filed a complaint against the petitioner before the deputy CEM lordship, district council lordship, for many reasons, lordship. The first reason being that the petitioner was usurping the Hima land. Secondly, lordship, he had given land to the government without the approval of the Darbar Hima. Thirdly, lordship, the main reason, that is, he had received an amount of about 14 to 15 crores.
What is your locus?
Locus, lordship, I am the respondent number 6. I have signed the affidavit as the president of Seng Samla Hima Langren, but the complaint was made along.
How are you connected with the affairs of the Hima?
I am an inhabitant of Hima Langren, lordship. I am a subject Kikun Kihajar of Hima Langren. As such, I am a beneficiary to whatever is done or not done by the petitioner, lordship. That is my locus, lordship.
But you are an NGO.
Lordship, I'm from the Seng Samla, but the complaint was filed not just by me alone, but also Kikun Kihajar of the Hima, lordship. So basically, overall in total, the complaint is not filed by an NGO individually. It's along with the Kikun Kihajar of the Hima, lordship. That is our locus, my lord. Lordship, the main reason is that 14 to 15 crores has been received by the petitioner for land compensation, lordship. And it came to our knowledge that 77 lakhs was given to a church. Lordship, was only after the writ petition was filed, we have learned that it's 2 crores 21 lakhs that has been given to churches instead, when that money was meant for the Hima, lordship. Directly or indirectly, we are supposed to be the beneficiaries of any revenue that comes to the Hima, lordship. Then, lordship, apart from that, lordship, the rules, lordship. My seniors have gone through the rules of 2010, 2015, 17. I'll not go into that, lordship. But as a person who is an inhabitant of Hima Langren, lordship, 2010 rules and 2015 rules, lordship, they've taken away my participation in the Darbar Hima, lordship. That is also one of the reasons I had filed this complaint before the district council, lordship. Because section 12 had allowed for some elders of the Hima to participate in the Darbar Hima, along with the same deputy same and other office bearers. But 2010 and 2015, lordship, they've taken away that right. So Lordship, that is the reason why I have filed the complaint before the District Council.
Who was taking that, right? The district council or the CM was taking
That is the amendment to the Hima Langrin rules, Lordship, for second amendment, and also the rules of 2015, Lordship. So that is the Dorbar Hima itself, Lordship. This when the same was in power. So he had taken away the right of the residents, the individuals, the inhabitants of the Hima to participate in the Dorbar Hima, Lordship, whereby only the office bearers would now have a say in the functioning and the conduct of business of the Hima, Lordship. Having agreed by these reasons, Lordship, we had filed the complaint before the District Council, Lordship. Lordship, in furtherance of the same, I rely on the submissions made by my learned seniors, Lordship, because my role as Kikun Ki Hajar is limited to filing of a complaint when I am aggrieved by the acts of the chief of the Elaka, my lord. So that is my submission, Lordship.
Yes, Mr.
Your Lordship, before I forget, I'll just reply to respondent number 6 first.
How long will it take for you to?
I will not take long, very short. I've just made some points, I'll just read that. My learned friend just made a submission that they are aggrieved by actions of the petitioner and the manner in which he is holding office. This is Seng Samla, and the complaint has been filed under the letterhead of the Seng Samla. The manner in which how those signatures were procured, I have already made submission before your Lordship. Many signatures are repeated signatures. Complaints have been filed against them. Now they are aggrieved with my actions after I received the compensation amount. Number one. Number two, they are aggrieved of my of the framing of the rules of 2010 and 15. When the 2010 came, your Lordship, where were they? We don't know. When 15 again it was amended, where were they? We don't know. Now in 2023, they come and say because our rights have been taken away. And that also not by way of a proceedings challenging the rules. By a complaint filed before this district council, who the district council themselves have approved those rules. And the district council themselves has sent it to the district council affairs for publishing of the same. Now, that is my reply to my learned friend. Rather, my learned friend has gone into the merit, trying to be very emotional with them, with whatever grounds he's taken. But the fact remains is that she's a NGO, a busybody, which has been motivated by some vested interest to file this complaint. And that too now. If they really agree, repeat it again, if they really agree by the acts and rules, they should have filed a correct procedure challenging the virus of those rules. That was not done. Now they come up with some emotional plea that they've taken away my rights. In my humble submission, that submission it has no legs to stand, Your Lordship. It's a politically vested complaint by somebody. Now, secondly, Your Lordship, in reply to the district council. They've made some emotional submissions on merit regarding the money always, and the confidence, which I have not gone through. My submission before this court is with regard to the procedure that has been laid down, whether it should be followed or not. That's my submission. Now, 15 crores has been given to some churches, no doubt. Though their allegation is 7, I have revealed more than that. Why? Because I have donated as a public interest also, which those churches also have accepted. It's in the nature of a public interest also. And the money which they say that I have not revealed in the what they have directed me to furnish the status of the money, I have submitted only the amount that is with the Darbar, because this money was withdrawn by a management board, which is the Darbar Hima and the matter which was settled between the Darbar Himar and a private party, who was the grandmother of the petitioner. That was settled since 2011. That is why we have formed a management board who will take care of both that properties. Whatever revenue generated from that two properties will be run by the management board. There's nothing as such with the management board which they have raised till date. And thirdly, Your Honor, the suspension pending inquiry. The judgment which was not reported relied it upon. Your Lordship has put a query whether there was a preliminary inquiry or not. In instant case, as has been relied upon in the Supreme Court judgment, in that case there was a preliminary inquiry. Then only action was taken against me. Now in this instant case, there's not even a reference of any preliminary inquiry. I was asked to file a show cause. I have filed my show cause. Thereafter, they issued me a notification which does not reflect a single line which says that I have been suspended pending inquiry. That order is impugned in the writ petition, which we have challenged in the writ petition. It says, Executive Council has suspended the function of NACTICM as CM of law. It only says suspended.
Yes.
Now the order which they have furnished me later on says, does not even reflect under which provision is it, which Your Lordship has rightly pointed out. So where is there that there's any suspension pending inquiry? In fact, Section 7 has been violated because no opportunity was granted to me for hearing. Other Learned Senior has interpreted Section 7 saying that it is not a punishment. Action can be taken against me, suspending me pending inquiry. Now there are two aspects interpretation of Section 7, Your Lordship. If it was a case that a complaint has been filed before the District Council and the District Council on the basis of the complaint finds that prima facie there is a case in the complaint, they can directly suspend me pending inquiry. That I have nothing to say. Now what has happened in this case? Firstly, they've issued me a notice whereby they have freeze my account. Thereafter, they issued me a letter to show cause. I have replied to the show cause. Now, why is it so? Once the proceedings are being taken by the Executive Committee, it has to proceed in accordance with law. Now, it cannot end abruptly upon my show cause saying, like, no, now you're suspended pending inquiry. You have to proceed, allow me, give me an opportunity, hear me. Now, after hearing me, if you find that, fine. We are not satisfied with whatever you have submitted, we'll suspend you pending inquiry. Then I'm happy. That has been violated also. That's those points. The suspension inquiry, Your Lordship, I have submitted that it has been done without any opportunity. Because they've seized of the matter. They have already taken up with the matter.
See, the reference is made to the rule which says that in case of emergency, you can be suspended. No, pending.
It's understood. That is understood, but it has to be interpreted in the correct manner. They seized of the matter. They took the complaint. They issued me letters. They issued me show cause notices. I replied. Then the question of hearing should have been there. Then suspend me pending inquiry, being non-satisfied. That was not done. Now, with regard to the publications of these rules were framed under the powers under Section 11 of the Act. Because Section 11 of this Act says you give the power to the Executive Darbar to frame rules. Accordingly, the rules were framed. Now powers are there. Now after the rules were framed, it was taken to the district council themselves. They have approved. They themselves got it published also before the Gazette. I'll draw reference to other sameships, non-stain sameships, other sameships which have placed, Your Lordship. They were done. But why in this case there's a, pick and choose. Now, another submission, Your Lordship, is with regard to the rules cannot override the Act. Now, the Act will confine only to the appointments, Your Lordship, suspensions, and then other things. Now, why the rules are required? The rules are required to elaborate on the duties, the powers, and the functions of the SAM, the Deputy SAM, the Darbar Hima, the Executive Darbar. That is why the rules are framed to elaborate on their functions. Because the rules were framed, why it was framed? Because it has to protect the customary practices. Now, I'll read what is the preamble of the 2010 rules. I'll rely on the compilation which my learned friend has submitted before this court. Page
17.
Yes, Lord.
Yes.
Whereas Section 11 of the Khasi Hills Autonomous District Nomination and Election of the SAM, Deputy SAM, Headman of Longing Exemption Act 1900 empowered the Executive Darbar to make rules for day-to-day general as well as revenue administration of the SAMship in accordance with the prevailing customary practice in its administrative rights, which has been in practice since time immemorial. And whereas it is expedient to safeguard and preserve the prevailing customary practices of Langren SAMship, which has been in practice since time immemorial, and to make such provisions for smooth functioning of Langren SAMship. Now, firstly, when the Act was brought, Your Lordship, was enacted, there were two things. Complaint should be brought before the Darbar Hima, and number two, he shall not be suspended without giving an opportunity of hearing. That was amended in 2010. Now the Darbar Hima part, where the complaint has to be put before a Darbar Hima, that was deleted, which I admit to that. Now they're trying to say that the rule cannot override the Act. Now, where's the question of overriding? Where's the question of contrary? What they're saying is that it's contrary. Is there anything contrary, Your Lordship, when, because this is the customary practice, is that if there's any complaint against the chief, it can be brought before Darbar Hima, and Darbar Hima can elect any person as a chairperson to preside over. It's not like they're scared before the SAM because he is ruling. I have been elected by the general public. If I have to be removed, the general public will remove me. They still have the confidence in me. Another aspect, Your Lordship, that is on account where the rule has come to protect, to safeguard the customary practice. That is why that Amendment 3/2015 was brought in. There's nothing overriding. There's nothing contrary.
Yes. Yes.
Because the rules cannot really be confined to, it has to be more elaborate on the duties and functions of the SAM. How a complaint is to be filed, what are the duties of the SAM, what are the duties of the acting SAM, what are the duties of the Executive Darbar, how are revenue generations be collected. Those are more elaborate in the rules rather than in the Act. That is why these rules were framed. These rules were framed 2010 amended 2015, put up before the district council, they approved, they had no problem, they had no issues. Now where is the problem coming? Where there's money, there's trouble. There's a wording they say. Now after the money has come, now they say this rule is like this, it cannot have the force of law, it cannot do this. But look at the manner in which the 2019 rules were framed. How is it framed? When the acting came for a short period of 8 months. Look at the manner in which they have infringed the rights of the Darbar people, of the subjects of the people. In 8 months, they've come to do a lot of things, Your Lordship. Came in power in 2019 on 21st of December after my suspension. January, constituted a Darbar, formed executive committee. February, everything amend, revise everything. And that also within their knowledge, never made public. Look at the exercise, the malified, the colorable exercise of the earlier incumbent and the district council. Now the district council is making a submission that we're trying to straighten up everything. Now, is this the way to straighten up everything, to suspend me? Want to straighten up something, you should consult also.
Oh, that is a different subject matter.
Yes.
It's just incidental to your case.
Absolutely, Rosh. Now they cannot say something and then now say something else. Because whatever we have done with the active consent, deliberation with the district council. What my learned friends have read about the 1951 rules, I have nothing to say. I don't dispute that. Those are the laws framed by the district council. But what are the peculiar nature of this case is that all the rules that were framed by the Darbar sent for approval to the district council. It was approved by them. They sent it to the district council affairs, got it published. Everything was done. They were the one who've done it. Now they take a contradictory stand. They think it has no force of law, not required to be published. Fine. But look at the manner of 2019, how it has been done. Natural justice demands that the general public also should know about these rules. They're not even aware about it. And 2010, 2015 rules, those submissions make now in 2015 that it has taken away the rights, and the district council also says that no, that it's not well-meaning, all that.
It's not in consonance.
That those was never challenged, Your Lordship. Never challenged by way of a correct proceedings. Can they take it out now by way of a complaint? If they want to declare all these rules as redundant, issue a notification saying whatever rules published so and so, because they have the power, they can do that. No, they wait for somebody's complaint to come to do all this. And who's the complainant? Those, Sang Samla, registered body, Sang Samla. In that letterhead, the complaint was filed, got signatures from those they get, what they can manage. Now, rules of liam, like I've submitted earlier, customary practice, means what? To codify. To codify the customary practice. If Your Lordship have time, we'll compare the rules framed in 2010, amended 2015, with the rule of 2019. How everything has been diluted.
So your suspension was under the 2019 rules?
No, under the Act.
Under the Act?
Under the Act, Section 7.
Yeah, so
what they say, but there's nothing is reflected in there.
As far as rule 2010, 15 and 19 are concerned, we are just discussing on the variance.
Yes.
Nothing.
Basically, my submission is that I have submitted earlier, not on merit, basically whether procedures have been followed or not. Because our contention is mainly against the district council, that I've counted almost all what my learned senior have submitted, Your Lordship. That's all. No? That I've submitted earlier. Section 11, under the Act, we have the power to make the rules. So that is why that was done, approved by them. Now,
only one point, my lord. Your Lordship will come to page 38 of the affidavit in reply of the petitioner to the affidavit in opposition filed by respondent number 5. Affidavit in reply on behalf of the petitioner to the affidavit in opposition filed by respondent number 5. Page 38, madam. This issue was pointed out on the last occasion also, because their submissions is that they have no knowledge regarding the revised rules of 2019. But here is a letter by the petitioner on 7/12/2021. The last paragraph which says that, therefore, I, the undersigned, humbly request your good office to instantly reject the changes, amendments with regards to the rules of administration of the HEMA of Langrin, if any, during the tenure of the acting CM, inasmuch as the same were brought about without the knowledge and consent of the CM and executive Durbar. If this was not consented to by the executive committee, because we have never replied, we have never amended.
You are referring to just a moment.
Page 38, ma'am. Page 38. Because they say that they are not aware regarding these the revised rules of 2017.
Yes. Oh, he says that later on he came to.
Yes. And the language used.
No, they came to learn and see what is their prayer in this letter.
Can you see the language? If, I said if.
Therefore, I, the undersigned, humbly request your good office to instantly reject the changes, amendments with regards to the rules of administration of the HEMA.
If any.
If any, during the tenure of
During
the
the
acting
tenure.
CM, inasmuch as the same were brought about without the knowledge and consent of the CM and executive Durbar.
If any, Lordship.
We are aware that these rules are there. He was the CM at that point of time. If it was his desire, he could have amended the rules again. What stopped him from doing that?
He's saying if there is.
No.
Obliged.
Honesty.
Much obliged. Would your Lordship like written?
It would be better. So much of.
Yes, because a brief. We'll give a brief.
Please.
By tomorrow, my lord.
If you do it, point wise.
Yes, point wise.
So it'll be better.
If none of us elaborate so much, Your Lordship will be able to
fact,
do it by
I've
tomorrow.
already prepared. Just on we can submit it tomorrow.
What is your stand?
Yes.
And what is your opposition to the contention of the
Your Lordship
petitioner and
has
vice
sought
versa?
for a citation of that judgment which I've earlier relied upon.
You can do that.
I'll just supply it.
No, you do that in your written argument.
I'll just place the judgment. I'll give a citation in my argument.
Please do that. So when do we do it?
I can do it by tomorrow also, because there is a point.
Leonard Senior had a very limited sort of a submission.
So let it Monday, Tuesday.
How long?
Tuesday, Lordship.
One week
Tuesday,
time.
everyone should file on Tuesday, not taking time, Your Lordship.
Tuesday.
All of us should file at the same time.
I think it's still fresh in my Lordship.
Your Lordship.
Head also. Otherwise, we keep
Because
it too long.
On Tuesday, I filed and she says, I'm not ready, give me some more
All
time.
of us will
Then,
file.
if nobody files on Tuesday, Your Lordship may proceed with judgment.
Letter counsel for the parties on preamble the points of written argument, points of argument in written form is allowed to be filed
On Tuesday.
on the next date fix. This is matter on
26.
26.
Much obliged.
Obliged.
Item number 11.
May I please, Your Lordship, Lordship, I'm appearing on behalf of the petitioner, Lordship.
Just a moment.
Lordship, there's a scheme which is flouted by the government, Lordship. So the petitioner has already applied for the benefits of the scheme, the amnesty scheme. So we are just waiting for the results to be out, Lordship. In the last occasion also, my senior counsel, Dr.
Yes, you
Saraj,
have said the same thing, that amnesty scheme is...
is also it's the same.
So how long?
Yes, the same. We are still waiting for the results, Your Lordship.
How long?
Lordship, 8 weeks, Lordship, hopefully, Lordship.
8 weeks.
8 weeks, Your Lordship.
Letter counsel for the petitioner has submitted that the amnesty, the formalities as regard the amnesty set proposed amnesty scheme has not yet been finalized, and has submitted that some time may be allowed for the same to be finalized and a report to be placed before this court. On premium, this is matter of 8 weeks, you say?
Yes, Your Lordship.
Would it take that much time?
We are just ascertaining, Your Lordship.
Will you? This is a matter of 4 weeks, then we'll see after that.
Oh, okay.
This is a matter of 4 weeks.
Hello.
Much obliged, Lordship.
Hello.
Item number 12.
Wait, please, Your Lordship.
Yes.
This is the case, my lord, of supply of water during the flash flood. Your Lordship would recall that this was argued by the petitioner, and then I also submitted I made my submissions on last date of hearing.
So what is required here?
Learned he is about to conclude his argument today. Substantially has finished. He wants to cite one more judgment.
I'll just place the bare minimum facts so that in that context, my lord, I can place this case.
Then can you do one thing,
the case
Mr. Kumar?
Yes, sir. Yes, sir.
If the argument has been completed, then can you just file a written argument with the whatever authorities you have?
Why not we give some? We need to give some response, madam, after the learned AG concludes. Maybe 10-15 minutes respond only.
But to now, firstly, time is also.
Maybe next week, if Lordship, subject to Lordship convenience.
This court will not be able to sit in the second half.
Yes. Next week, subject to Lordship
We
convenience.
have a program.
Yes. Oh, yes.
So, we'll fix it next week.
Your Lordship may have it next week. Your Lordship may have it next week.
Yes.
I will be ready with my written synopsis also, and my friend will be ready, and then we can conclude the hearing in this matter.
Yes. On pre-made by the parties, this is matter up to 1 week.
Thank you.
Right.
Item 13, I am the petitioner. So
Connected.
So 12, 13, same order.
Both matters will not.
Thank you.